is United States versus Eichman. It's the name of this case. It was argued on May 14th, 1990, set in June 11th, 1990. The reason we're talking about these cases is because of the lapse of freedom of speech in our country under the George Bush administration. After this, the court held in Texas v. Johnson, 491 U.S. 397, that a Texas statute criminalizing desecration of the United States flag in a way that the actor knew would seriously offend onlookers was unconstitutional as applied to an individual who had burned a flag during a political protest. Congress passed the Flag Protection Act of 1989. The act criminalizes the conduct of anyone who knowingly mutilates, defaces, physically defiles, burns, maintains on the floor or ground, or tramples upon a United States flag, except conduct related to the disposal of a worn or soiled flag. Subsequently, appellees were prosecuted in the district courts for violating the act, some for knowingly burning several flags while protesting various aspects of the government's policies, and others in a separate incident for knowingly burning a flag while protesting the act's passage. In each case, appellees moved to dismiss the charges on the ground that the act violates the First Amendment. Both district courts, following Johnson, Supra, held the act unconstitutional as applied and dismissed the charges. Held appellees, I don't know which one it is, prosecution for burning a flag in violation of the act is inconsistent with the First Amendment. The government concedes, as it must, that appellees' flag burning constituted expressive conduct, and this court declines to reconsider its rejection in Johnson of the claim that flag burning as a mode of expression does not enjoy the First Amendment's full protection. It is true that this act, unlike the Texas Act law, contains no explicit content-based limitation on the scope of prohibited conduct. Nevertheless, it is clear that the government's asserted interest in protecting the physical integrity of a privately owned flag in order to preserve the flag's status as a symbol of the nation and certain national ideals is related to the suppression and concerned with the content of free expression. The mere destruction or disfigurement of a symbol's physical manifestation does not diminish or otherwise affect the symbol itself. The government's interest is implicated only when a person's treatment of the flag communicates a message to others that is inconsistent with the identified ideals. The precise language of the Act, page 311, prohibition confirms Congress' interest in the communicative impact of flag destruction, since each of the specified terms, with the possible exception of burns, unmistakably connotes disrespectful treatment of the flag and suggests a focus on these acts likely to damage the flag's symbolic value, and since the explicit exemption for disposal of worn or stolen flags protects certain acts traditionally associated with patriotic respect for the flag. Thus, the act suffers from the same fundamental flaw as the Texas law, and its restriction on expression cannot be justified without reference to the content of the regularly rated speech. Booz versus Barry, 45 U.S. 312-320, and must therefore be subjected to the most exacting scrutiny. And for the reasons stated in Johnson, the government's interest cannot justify its infringement on First Amendment rights. This conclusion will not be reassessed in light of Congress' recent recognition of a purported national consensus favoring a prohibition on flag burning, since any suggestion that the government's interest in suppressing speech becomes more weighty as popular opposition to the speech grows is foreign to the First Amendment. While flag desecration, like virulent ethnic and religious epithets, vulgar repudiations of the draft, and scurrilous caricatures is deeply offensive to many. The government may not prohibit the expression of idea simply because society finds the idea itself offensive or disagreeable. That's in Brennan. Delivered the opinion in the court, in which Marshall, Blackmun, Scalia, and Kennedy um, and Stevens joined. Stevens filed a dissenting opinion, in which Rehnquist and White and O'Connor joined. And so there we have it. We're allowed to burn the flag in our country. But are we allowed to walk the streets of Lebanon, New Hampshire in our country? That only time will tell, the courts will tell. In most cases, when somebody's speech is protected, it's protected. And the cases are dropped. And in some cases, I guess they go all the way to the Supreme Court. And you get out of these territorial regions of the country, and you start to see some intelligence. Even in cases that, and you got to understand, this is a basically Republican-packed court. This court was packed by, I believe, Reagan and Bush. And so, a matter so hardy as desecrating the flag, or not desecrating the flag, depending on your viewpoint. The Supreme Court has quite recently stated that it's not okay, but the First Amendment protects it. And so, no matter how terrible that conduct is, it is protected under the First Amendment. The two reasons why, and actually the NHCLU has told me personally that this freedom of speech cases are difficult cases, and I'm saying just the opposite. They're simple cases. Two exceptions: crying fire in a crowded theater, so you can't cause some kind of chaos, and the other exception, let me think. Oh, fighting words. And fighting words, of course, in some ways need to be defined, and I'm sure the courts have done that. But those are the two major exceptions. Now you tell me how hard it is to decide that. Now fighting words, we might get into some complications on how hard it is to decide. But basically, those are the exceptions. So I thank you for your time. This is my series of lectures or talks regarding First Amendment rights. And since the ACLU hasn't done that, Bucklaw will. And, I appreciate your time once again. Hope you learned something today.